In this podcast, we're going to focus on the idea of rights, not the substantive area of rights, but the concept of human rights and the development of that idea. In the latter portions of the podcast, we'll consider human rights charters and legislation and the impact of these. We'll look at the extent to which these have protected the rights of individuals. We'll also ask whether there are cultural differences between the signatory states to the international charters, which result in varying interpretations of rights around the world. We'll also contemplate whether this has led to some individuals losing out in different parts of the world, and discuss whether it's ever acceptable for some countries to claim cultural differences which enable them to ignore certain human rights, for example, the rights of women. In terms of the structure of the podcast, it will be delivered in 3 parts. In the first part, we will consider the first 2 questions on the slide. What are rights and where do they come from? In the second part, we'll consider how these have been formalised at a national and international level, and whether that codification has offered individuals protection. In the third and final part, we'll ask the question, what's wrong with rights? And begin to examine whether rights should be understood to be universal in nature, or whether there is any room to argue for cultural relativism. More on that in the latter portions. We start then with a very basic, fundamental question. What do we mean by rights? What are rights? Why are they important? What would be the status of individuals if there were no recognised rights? As a broad class of political philosophers, liberalism considers individual liberty to be the most important political goal. It emphasises individual rights and equality of opportunity. Within liberalism there are various streams of thought which compete over the use of the term liberal and may propose very different policies, but they're generally united by their support for a number of principles, including freedom of thought and speech, limitations on the power of governments, respect for the rule of law, an individual's right to private property, and a transparent system of government. Crucially, liberals would generally support open and fair elections where all citizens have equal rights by law. But why is it that rights are so important? Joel Feinberg was an American political and social philosopher, and is known for his work in the fields of individual rights and authority of the state. Of rights he said, having rights enables us to stand up like men, to look others in the eye, and to feel in some fundamental way the equal of anyone. To think of oneself as the holder of rights is not to be unduly but properly proud, to have that minimal self-respect that is necessary to be worthy of the love and esteem of others. A strong statement in support of rights. But not everyone views rights as fundamental, or even as a real concept as such. For example, utilitarian philosophers are sceptical about the idea of rights. As a specific school of thought, utilitarianism is generally credited to a gentleman named Jeremy Bentham. Bentham found pain and pleasure to be the only intrinsic values in the world, saying, "Nature has placed mankind under the governance of 2 sovereign masters, pain and pleasure." From this he derived the rule of utility. The good is whatever brings the greatest happiness to the greatest number of people. Later this was more generally referred to as simply the greatest happiness principle. But in general, utilitarianism is the idea that the moral worth of an action is determined solely by its contribution to overall utility, that is, its contribution to happiness or pleasure as summed amongst all persons. The government therefore must treat people as equals, thus nobody has any greater entitlement to have his preferences fulfilled than anyone else. The only reason for denying one person his desires is that more or more intense desire must be fulfilled instead. These are situations in which overall average satisfaction of desire is greatest, so therefore, under this school of thought, rights would always succumb to the general welfare. But in response to this scepticism, Ronald Dworkin, an American legal philosopher, says that rights are trumps. By their nature, rights are allocated to protect particularly strong personal preferences, so strong in fact that they always outweigh the interests of the collective. Rights can only be overridden to prevent a catastrophe or to obtain a clear and major benefit. That is, he acknowledges that they're not literally always absolute, but there is always a strong presumption in favour of the right prevailing. So, having established a little about the concept of rights in general, what are the fundamental human rights? What do we mean? Well, there is no universally accepted definition of human rights. It can mean a number of things, so it may well fall under different categories or classes, such as economic rights, which might include the right to a minimum standard of living, or the right to housing, the right to work or set up in business. It may refer to political rights, which could include the right to demonstrate, i.e. to march in the street and protest about a law or policy, the right to publish something derogatory about a politician, the right to put yourself forward as a candidate in an election in opposition to the politician currently in office, or perhaps even more fundamentally, the right to vote in a democratic society in free and fair elections. But it may also include social rights, the right to equality on grounds of sex, race, religion, disability, age, sexual orientation, etc. All these are things which those running a state should not interfere with in a negative sense, or in a more positive sense should ensure exist. But how do we decide what human rights there are? Where do we get this idea of there being a certain set of rights that are fundamental? What are the origins of human rights? There are, of course, a number of theories advanced in order to try and explain this. On the slide is a depiction of Adam and Eve, the story of whom many will be familiar from the book of Genesis. It isn't surprising that one of the theories that has been advanced as to explain where rights come from is that their origins are in religion, and in particular religious ideas from the Abrahamic tradition, the monotheistic faiths that recognise a spiritual tradition of worship of God. So collectively here we're referring specifically to Judaism, Christianity and Islam, all of which effectively share the same roots. And some argue that the idea of human rights can be traced to this tradition, in that there is a law higher than the state whose source is the supreme being. The fact that there is a universal common father means that humanity is part of a common community that therefore endows us with worth and dignity, and logically leads on to a universality of certain human rights. This idea of a natural order, a natural law, natural rights was adapted and appropriated by the Roman and Greek philosophers, whose conceptualization of natural law was that there was a law higher than positive, i.e. man-made law, which was discoverable by human reason. They did, however, retain some elements, an idea of divinity in their philosophy. Roman philosopher Cicero said, "True law is right reason, in agreement with nature. It is of universal application, unchanging and everlasting. It summons to duty by its commands, and averts from wrongdoing by its prohibitions. And it does not lay its commands or prohibitions upon good men in vain, although neither have any effect on the wicked. It is a sin to try to alter this law, or is it allowable to attempt to repeal any part of it, and it is impossible to abolish it entirely. We cannot be freed from its obligations by Senate or people, and we need not look outside ourselves for an expounder of it. And there will not be different laws at Rome and at Athens, or different laws now or in the future, but one eternal and unchangeable law will be valid for all nations and all times, and there will be one master and rule, that is, God over us all, for he is the author of this law, its promulgator and its enforcing judge. Whoever is disobedient is fleeing from himself and denying his human nature, and by reason of this very fact he will suffer the worst penalties, even if he escapes what is commonly considered punishment." Cicero's argument was that true laws, and consequently true rights, are entirely natural, inherent, intrinsic and timeless. In terms of the main points of natural law as an argument, is that it has God or goodness as its source, it's discoverable by reason, it cannot be repealed, is universal in that it applies at all times and all places, and that a man-made law which conflicts with it is not true law. The idea of natural law was appropriated by Christian philosophers in the medieval period, notably Thomas Aquinas and St. Augustine, i.e. that natural law equaled God's law. This idea continued to be the main philosophy as to the root of law and the foundations of rights for some time. A more rationalistic and secular model was reintroduced by a number of philosophers such as Grotius and Pufendorf, that natural law conformed to the natural impulse of men and women to live peacefully, or that it would be a dictate of right reason, similar to the ancient Roman justification for the support of natural law. Then came the apparent Age of Enlightenment from the 17th century onwards. In the late 1600s there were emerging ideas on the basis of a social contract theory, which is the view that people's moral and or political obligations are dependent upon a contract or agreement between them to form a society. It's not strictly true to say that this idea was new in the 17th century. Socrates used something quite like a social contract argument to explain some theoretical principles in his day. However, social contract theory explicitly is rightly associated with modern moral and political theory, and is given its first full exposition and defence by Hobbes, Locke and Rousseau. At a basic level, social contract theory relies on conceptualising that humans by nature would be in chaos, and that people would take what they wanted, would kill whomever they thought would be in their way, and that this state of nature is unsustainable. So the argument goes that people left this state of nature by mutually agreeing to set up a body politic, a ruling government, and in exchange for its power, the government was obliged to protect the natural rights of life, liberty and property. If government neglected this obligation, it forfeited its right to govern. Life, liberty and property were the natural rights because these were the rights that made self-dependence possible, i.e. natural necessity. Such social contract implies that the people give up some rights to a government and or other authority in order to receive or jointly preserve social order. Social contract theory provides the rationale behind the historically important notion that legitimate state authority must be derived from the consent of the governed. The social contracts and the civil rights it gives us are neither natural rights nor permanently fixed. Rather, the contract itself is the means towards an end, i.e. the benefit of all, and, according to some such as Locke or Rousseau, is only legitimate to the extent that it meets the general interest. Therefore, when failings are found in the contract, we renegotiate to change the terms, using methods such as elections and the legislature. Locke theorised the right of rebellion in case of contracts leading to tyranny. And so, quite rightly, the idea of the social contract theory formed the theoretical groundwork for a legitimate representative democracy. In the 18th century, there were revolutions in both America and in France, and these new democracies began to weave the concept of human rights into codified form. The US Constitution incorporates rights as a fundamental principle. And really, for the first time in human history, they began to develop an international understanding of formally codified rights. In the second part of the podcast, we will take a look at this codification of rights and whether or not it has served to protect individuals. In the first part of the podcast, we were considering the concept of rights and how they evolved. In this part, we look now to consider the idea of codified human rights, and we saw at the end of the last portion of the podcast that this idea dates back a couple of hundred years, and fundamental rights began to be incorporated into many Western legal systems in the form of constitutions. But on the international stage, the idea starts with the United Nations, and specifically with the UN Charter. In its preambles, it declares as a primary purpose of the United Nations promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language or religion. The picture displayed is a mass grave in Belsen. It was the atrocities of the Second World War which were a catalyst for the formation of the United Nations and the United Nations document. In particular, the ability of the German states in the 1930s and the 1940s to limit the rights of certain members of its population. This applied essentially to those seen as opposing the state or not conforming to a particular vision of the state. Individual rights were sacrificed to the needs of the state machine. Thus, Jews were ultimately murdered on a large scale alongside Catholics and homosexuals. The disabled were initially sterilised and then murdered. All were targeted as enemies of the state. Other sections of the population, such as women, also saw their rights significantly curtailed. And the extreme policies and laws of Nazi Germany contributed to a feeling after the war of the need for international cooperation and an internationally recognised document in which the signatory countries promised to respect the rights of their populations so as to avoid a recurrence of the Holocaust. 3 years after the Second World War, in 1948, came the United Nations Universal Declaration of Human Rights, which says, whereas recognition of the inherent dignity of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world, all human beings are born free and equal in dignity. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. The UN Declaration was the first major international document signed by many different countries. There had been treaties and agreements between countries before this time, in which they had agreed to recognise some common ideals such as each other's sovereignty, or not to wage war against each other, and to allow each other's citizens certain freedoms. There are some minor examples of earlier international cooperation on human rights, but it was the UN Declaration which put internationally recognised human rights more firmly on the map and was the most universally recognised document. The UDHR was adopted by the UN General Assembly as a common standard of achievement. It is not, however, a treaty. It was intended to be inspirational and aspirational. However, today many of its provisions have become part of international customary law. In 1966, the UDHR was codified with the adoption of two covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Today there are numerous international human rights instruments which have widened the scope to include racial discrimination, gender discrimination, prisoners' rights, children's rights and refugees' rights. And very importantly to the UK in terms of the major human rights instruments would be the European Convention on Human Rights and the Human Rights Act of 1998, which came into force in English law on the 1st of October 2000. So has this codification of human rights really protected individuals fully? Well, there are some minor exceptions which could potentially have a major impact. Specifically here we're talking about derogations during states of emergency. Civil and political rights may be derogated from during a state of emergency, and to derogate from human rights means to limit the extent to which these obligations apply. These derogations are exceptions which are afforded to states so that there can be potentially occasions when they can effectively ignore the conventions to which they are signatories. Usually, as just noted, this will be at a time of emergency, but the state itself will decide when this is and what constitutes a state of emergency. It could be a natural disaster such as times of flood, or at times of war or civil war, or at time of an illness or epidemic. At these times, the the state can derogate from civil or political rights. People can be forcibly imprisoned by the state for the good of the public at large. This is then a dangerous situation for the individual. It is therefore meant to be exceptional and rare for a state to declare a state of emergency, and the derogation clause is to be found in Article 4 of the Convention on Civil and Political Rights. On the slide here is a general comment from the UN Committee on Human Rights in respect of Article 4. It says the committee holds the view that the measures taken under Article 4 are of an exceptional and temporary nature only, and may only last as long as the life of the nation concerned is threatened, and that in times of emergency the protection of human rights becomes all the more important, particularly those rights from which no derogation can be made. So in terms of an example of the sort of derogation we're talking about, consider an epidemic of a particular disease. We have a natural right to liberty, to freedom, but in the case of an epidemic, the state may quite rightly impose quarantine and therefore deprive population or members of the population of their liberty, and that's in the interest of preventing a natural disaster in terms of the spread of a pandemic. In terms of the criteria then for a lawful derogation, they must be temporary only in nature. There has to be an exceptional threat to the life of the nation, so something along the lines of civil war or a natural disaster or illness, as stated already. There has to be an official proclamation of a state of emergency that's made, and notification to other states and or the relevant treaty monitoring body. There has to be reasonable proportionality as well between the means employed and the end to be realised. So, for example, you couldn't do something which was wildly unnecessary to solve the threat to the life of the nation, and other obligations under international law remain applicable throughout. One thing that does need to be noted as well is that measures that are taken to derogate must not be discriminatory in nature. So for example, it wouldn't be appropriate to, for example, deprive the liberty of only women or only persons of a certain ethnic group or certain religious belief or homosexual men, for example, as that would be akin to the sort of activity that was seen in Nazi Germany, the very sort of activity that the International Human Rights Cooperation came about to prevent. And there are some rights which are considered to be so fundamental that even in times of extreme emergency, states cannot limit their application. And there's these certain rights that are considered so fundamental to a liberal, civilised society in the modern world that they're common to the many different charters on human rights across the world. Not all of them are necessarily considered to be absolute rights. For example, the right to life is qualified in the sense that lawful executions are permitted in accordance with a criminal justice system. However, the right to life should otherwise be respected. Torture is generally considered to be an absolute right with no possibility of any exceptions to that. The other non-derogable rights include the freedom from slavery, the freedom from post facto legislation, i.e. legislation after the fact, criminalising an activity after you've already done it, the right to recognition before the law, and the freedom of thought, conscience and religion. But we can already consider then that there are some limits to and some exceptions to these supposedly fundamental human rights. And on the basis that there are limits to them, then that presents us with some significant problems. In the third and final part of the podcast, we're going to consider more generally what's wrong with rights. In this third and final portion of the podcast, we're going to consider what's wrong with rights. One of the first fundamental issues really that can be raised is that there is no absolutely accepted definition of what constitutes a right and what in particular should be respected. At a much more basic level, there is, however, a common core of human rights agreed upon by all members of the United Nations. And these are that political imprisonment, political killing, disappearance and torture should not be allowed under any circumstances. But even these, however, are not always respected by the member states of the UN, and still indeed aren't always respected today. China, for example, retains a high level of political imprisonment. In Chile in the 1970s, the new military government killed any person who had spoken in opposition to it. And in Cambodia, also in the 1970s, a communist organisation under Pol Pot was responsible for systematically rounding up and murdering almost a third of the whole population as soon as it gained power. Torture is also routine in numerous countries. So despite an agreement in principle on these issues, human rights abuses still take place. The United Nations itself has been at the forefront of human rights activism and trying to protect human rights. It's continued to campaign for human rights across the world. It acts as a watchdog to record violations of human rights. It also tries to prevent these by persuading states that countries on the international stage are aware of these and disapprove of them. In this way, they have attempted to ensure respect for the Declaration of 1948. They have also tried to end civil wars by stationing troops in countries, peacekeeping forces, for example, in Bosnia and Afghanistan, though these have been met with mixed success. Its members might also introduce economic sanctions against such countries separately from the UN. Unfortunately, UN and various government human rights activity is selective and is politically motivated. For example, it's very difficult to be critical of the human rights record of China while simultaneously trying to establish trade agreements with China. So therefore, NGOs, non-governmental organisations, are often the most objective and effective proponents of human rights. As the name suggests, they are independent, not representing any particular government, and so are more likely to be critical and make the public aware of a country's poor human rights record. Today, there are scores of human rights groups who protest violations throughout the world. There are a number of examples of such organisations on the slide here, the most notable of which is perhaps Amnesty International, which includes members from around the world who will criticise countries other than their own to prevent them themselves being targeted and harassed by their own governments because of their criticisms. Amnesty was, as an example, very critical of the violations of the UK of the rights of Catholics in Northern Ireland during the times of the Troubles, particularly in relation to the arrest and torture of suspects who were being detained by the UK government on grounds of being terrorists. And they continue to be vocal in respect of the treatment of prisoners in Guantanamo Bay, for example. But having said that there are all of these organisations who campaign tirelessly to improve the position, atrocities still go on. But in defence, or possibly partial explanation at the very least, of why this is the case, let us consider for a moment who was responsible for drafting all of the international human rights documentation, charters, conventions, treaties, etc. They were mostly drafted by democratic and Christian countries in the developed world. It is true to say that many of the countries who have been at the forefront of drafting international human rights documents have been themselves Western, democratic Christian countries such as the USA and those in Western Europe, i.e. the First World or the industrially developed world. They have then often criticised the human rights records of countries who differ from this Western Christian norm, this model that is constructed solely by Western minds. So they've been critical of countries which are non-Christian or Muslim, such as Turkey. They've been critical of the less industrially developed countries or third world countries, such as many African nations. And have notably been critical
of countries who are not democratic, such as countries associated with communism, either now or in the past, like China. Many of these countries have committed, in inverted commas, crimes against humanity, but they have cited as an excuse their apparent cultural differences. They have said, sometimes without foundation, that either their religion or their culture and heritage allows for such abuses. Some have said that economically they need to limit the rights of, for example, workers to ensure development, or that politically they need to introduce a state of emergency to quell civil war between tribes in their country, so they may need to execute and torture prisoners. Human rights, though, as we discussed when talking about their origins, are meant to be universal. The UDHR refers to natural-born rights for all without distinction, in that it's intended to override any single culture or tradition, and that no right can be used at the expense or destruction of another in accordance with international law. But are human rights truly universal? In counter to the position that human rights are universal in nature comes the cultural relativist argument. That is an argument that human rights are not eternal and immutable. They're contingent upon time and place, and that culture helps to define identity. It's been said that the current formulation of international human rights contains 3 elements which reflect Western values and are only therefore relevant to Western culture. Firstly, that the fundamental unit of society is the individual as opposed to the family. Secondly, that the primary basis for securing human existence in society is through rights rather than through duties. And thirdly, that the primary method of securing rights is through legalism, whereunder rights are claims and adjudicated upon, rather than a focus on reconciliation, repentance, or education. Some examples of the sorts of cultural differences which show most keenly. In the West, we think of the freedom of the right to marry and the right to choose who you wish to marry. But in some African societies, the idea of child betrothal is common, with arranged marriages in return for monetary consideration. There's also the issue where widows can be inherited by the deceased husband's relative in societies where marriage is seen as alliance between families. The idea is that these young people are too immature to choose a spouse, or that the widows are protected by the new male guardian, almost like property, are abhorrent to Westerners who believe in an individual's right to choose, but culturally that's not the case. Also, in the West we would consider a person's bodily autonomy to be their own choice. But in Somalia, female genital mutilation is common practice, which again horrifies Westerners. Against this argument for cultural difference, the question begs, should everyone have the same freedom? This is what the international human rights movement calls for. It states that any cultural practice would be wrong if it has to be forced by coercion upon its recipient. The cultural relativist argument comes up time and time again and continues to be a problem even in Western society, as we live in a more pluralist and multicultural society. There can be clashes of rights. The freedom not to be discriminated against on the grounds of sexual orientation seems to clash frequently with the freedom of thought, conscience and religion, as just one example. And there are a number of other examples which most pointedly say that rights are far from an absolute solution. Rights are more difficult to put into practice than they are to theorise.